Okay, so now 17.8. The seller hereby warrants that he or she has the right to sell the property. This means that, yes, the people signing off this agreement as the sellers do have the legal right to sell this property. So it means that they have to be the owner, or if it's on behalf of a company or close corporation or a trust, they are the authorized person that may sign this offer to purchase agreement. Then 17.9. Neither the seller nor the agent warrants the correctness of the advertisements and the marketing material in relation to this specific property, nor the size of the stand, nor the square meterage of the buildings erected thereon, etc. So this clause means that, as I've explained earlier on, if the square meterage of a certain size of land indicates on the Lightstone report or CMA report that it's 1,000 square meters on the dot, but then the actual square meters is maybe 980 or 950. Then obviously we say here, listen, we do not guarantee the absolute correctness of the advertisement. There could be a typo on the ad as well, where the house was maybe indicated to be 220 squares, where the house is actually 200 squares. So obviously, more or less, the correctness of the advert, it cannot be guaranteed that everything will be absolutely 100% correct. But having said this, always make sure when you do your listing on the portals, make sure, double check or triple check your advert, or ask a colleague, listen, just go through the advert and see if you can see any mistakes. This is the size of the property that I have on the CMA info. These are the photos. Go and check your listing once it has been listed on the portals to make sure that you have the correct photos listed on that specific property. I've seen it many of times when I go and check properties on the portal where it's a very big house, and then suddenly there's a photo there of some sort of flat. You know, and I mean not a flat lit of that specific property, but a total different photo that doesn't add up on that specific listing. So it means that that agent actually added a photo that shouldn't have been there. Or the front view of the house, there's two different front views of that specific house. So it means that which one is now correct. So always go and make sure when you do your listings on the portal, make sure that your description of that property is 100% correct from what you got from either the Lightstone or the CMA property analysis. Make sure that your photos are correct and that your descriptions are correct as well. And then also make sure that things that you add, like solar, borehole, alarm systems, electric fencing, all those things that you do add, make sure that it also corresponds with the specific property that you are listing in order to avoid disputes in the future. Then if we go further down, POPI and SARS and non-resident of South Africa. So POPI just means that we are complying with the POPI Act. The seller and purchasers detail hereby give their consent. The sellers and the purchasers hereby give their consent to the estate agent and agency, and maybe the financial consultants, the attorneys, the inspectors, for compliance certificates, and all parties to this specific contract to process their personal information. So we do comply with the POPI Act, where we will then keep all the information that we do receive safe, and that we will not distribute this information to any other parties outside of this contract who doesn't have anything to do with this specific transaction. SARS, the seller and purchaser warrant and confirm that the tax affairs with SARS are up to date and will not cause any impediment to the transfer of the property into the name of the purchaser. Should a tax situation cause a problem, a delay, or a cancellation of the sale, the party concerned shall be responsible for payment of commission in terms of Clause 8, and damages to the other party in terms of Clause 9 hereof. So it means that if those things are not in order, again, it's actually a breach of contract, things are not in order, the sale is now falling through, then obviously the other party has remedies to go and sue the party who has now contravened or breached this specific OTP agreement. Okay, so if we go further down to clause 17.13, non-resident of South Africa. So this clause is only applicable where the purchase price is more than 2 million rand and the seller is a non-resident of South Africa. So it means that if you have a specific client that is a non-resident of South Africa and they are the sellers and the property value is 2 million rand or more, then this specific clause or paragraph will be enforceable. So if the purchase price is more than 2 million rand and the seller hereby warrants that he or she is not a resident of South Africa, upon interpretation of the Income Tax Act 58 of 1962, he or she hereby irrevocably authorizes and instructs the conveyancing attorney to deduct the applicable withholding tax from the purchase price on behalf of the purchaser and to pay this amount to SARS as directed by SARS in their legislation. Okay. This clause is applicable because there are some non-residents of South Africa that sell their houses, that sell their property, and they just return to wherever they came from without paying the tax that they should have paid to SARS. So it means that now legislation has come into effect in terms of the Income Tax Act to say, listen, the conveyancing attorney, if you, Mr. Seller, if you are a non-resident of South Africa and your property that we are selling is over the value of 2 million rand, we as conveyancing attorneys now have the right to withhold the tax that must be paid to SARS and to pay it over to them upon the registration of this specific transaction. Then if we go further down to clause 17.14, levies and or municipal accounts. So in the event that the seller has to pay levies and or municipal accounts in respect of a period beyond the date of registration, in order to obtain a clearance certificate, the parties here to agree that the purchaser shall then refund to the seller any amounts due in respect of the monthly levies and or rates and taxes after such date of registration on condition that the body corporate and or municipality does not hold the purchaser liable for payment of such fees. So this clause means that if there is any amounts due, but the property has now already registered in the buyer's name, then obviously the seller will then after registration still pay those amounts over to the body corporate or the HOA or to the municipality, but then obviously the buyer must now reimburse the seller of such amount. Then 17.15, severability. If any provision of this agreement is found or held to be invalid or unenforceable, it shall be deemed severable, meaning separate from the rest of the agreement, and the validity and enforceability of all other provisions and clauses of this agreement will not be affected thereby. So this clause then means that should there be any other paragraph or clause in this specific agreement that's not 100% correct or enforceable or invalid, then obviously we do not have to re-sign the whole agreement with all the parties. We just scratch that specific clause or that agreement in this specific OTP, but the rest of the contract is still then enforceable. So this just prevents the whole contract from being re-signed again. Then clause 18, other undertakings and conditions. So here you can specify any other conditions that the seller would like to be included or the buyer would be included. Any special conditions there could include, again, if the seller wants to specify on the OTP, listen, I am going to remove my alarm system. I am going to remove a specific SciCat that's very expensive. I'm not going to sell this property with that specific plant. Or I am going to remove an aircon or a chandelier or whatever the case may be. You can even include it into this specific conditions or special conditions. and then the buyer and seller can sign this agreement. But as I said, it's always better to maybe rather do that on the mandatory property disclosure document, and that document must then also be signed together with this OTP, and you must always present the disclosure document to your buyers when you do sign the OTP agreement, to also go through all the defects on the property, all the special conditions, the things that will be removed by the sellers, etc., so that the buyers are aware of all and any possible defects that the seller may know of, and anything that may be removed upon the sale of this specific property. If you go further down on page 16, the offer made at wherever it is on that specific date, the purchaser and co-purchaser must then sign the document, and once it is accepted by the seller, they must also sign to say accepted at wherever they accepted this document on a specific date. Seller 1 and co-seller as well must then sign on page 16 in full, and then again initial each and every page. Page 17 refers to the property practitioner's detail, your name, your surname, your FFC number, your mobile number, your email address, and then sign in full as property practitioner.